All right. So um, I'm going to go ahead and go into this. It's long-term care planning, what caregivers need to know. So I'm going to review some legal documents and some things that you just kind of need to be aware of, practical advice, and then some things. If there are questions, obviously, I'm happy to answer those. But um, without further ado, I'll jump into it. So some of the most important documents, one of which being a living will. So most people know the living will document. Um, well, it got national acclaim years ago from the Terry Schiavo case. That's the most popular one that people hear because there was she did not have a living will in place, and then the family fought over end of life decisions. The living will in the state of Kentucky, the language that has to be in a living will for it to be valid is set by statute. So if you go to that link down at the bottom, if you don't have one, if you are a caregiver for someone who needs one, if you go down to that link, the language that you need in a living will is at that link. And whenever we do them for people, we usually don't charge because all we do is put it on nicer paper. We cut and paste the language that's there and put it on nicer paper. But the main questions that are covered within a living will is you can name your healthcare surrogate. You can name a backup to your healthcare surrogate. You can choose whether you want to be an organ donor or not, or specifically what organs you want to donate. And then they ask you two specific questions. And they say, do you want life prolonging treatment or do you want nourishment and bodily fluids? So it's essentially you're talking about life support or you're talking about a feeding tube. And what you can do is when you fill this out, you can either say, yes, I do, or yes, I don't, and have your healthcare surrogate follow your wishes, or you can say, I don't want to make those decisions right now. I'm going to leave it up to my healthcare surrogate to make those decisions at the time that they need to be made. So, confidentiality issues with in regards to being a caregiver. If you're being paid to be a caregiver, especially, but in keeping information, there's a whole lot that goes into this. The HIPAA rules. Whenever we do a healthcare power of attorney, our healthcare powers of attorney are 4 or 5 pages long, where someone appoints somebody to be able to take care of healthcare decisions. And about 2.5 of those pages are just going over the HIPAA requirements, being able to get access to medical records. So if you are acting as a caregiver, obviously, don't pro-offer any personal or private information. Make sure that you have you have been designated as the healthcare surrogate or someone's healthcare power of attorney, which will allow you to get that information when you need it for the person you're acting as caregiver for. Like I said, there's the Health Insurance Portability and Accountability Act that covers, at its root essentially, if you don't have prior authorization to get or transmit someone's private health care information, just don't do it. I see where long-term care, assisted living, and hospitals get in trouble a lot of times from allowing this information to get out when they don't have the proper authority to do so. So who's allowed to disclose authorization or allowed to do it? Like I said, if you have been appointed as someone's healthcare proxy or surrogate, outside of that, when a judge makes you, outside of that, you are not under any obligation to disclose anyone's private healthcare information. So I mentioned a healthcare power of attorney. Healthcare power of attorney is important. My area that I practice in is elder law. So our healthcare powers of attorney are geared specifically for generally long-term care and having to deal with those issues later on in life. So we're not as concerned with health issues that might go with a new family or someone who is a small child. Our healthcare powers of attorney deal almost entirely with being able to allow caregivers or family members be able to take care of the healthcare decisions at the end of life, being able to get psychiatric treatment. Does the power of attorney allow you to get access to medical records? Does it allow you to decide which doctors, which medication that a person is to take? There's different kinds of powers of attorney. When we fill one out for somebody, generally the main question, a lot of times people are hesitant to sign a power of attorney immediately because they're worried that someone has the authority to act on their behalf right away, even when they might not need it at that time. So sometimes what we do is we put what's called springing language in our powers of attorney. And what that means is you put in the power of attorney that this person has this power to act on my behalf, but only once a doctor has signed off on the fact that I can't make decisions for myself, essentially. That language is called springing, which means it's not in effect, and then when a doctor says that you can't do it, that power springs into effect. This is another thing that caregivers might not be aware of in terms of taking care of someone. This generally goes along with professionals, but it's pretty general what it covers. And essentially what it is that if you have reason to believe that there's abuse, neglect, or exploitation in regards to anyone that you have essentially a fiduciary responsibility for, if you're acting as someone's caregiver, I believe that falls into that gamut. If you are a medical examiner, alternate care, caretaker, having reasonable causes to suspect that an adult has suffered abuse, neglect, or exploitation, you have to report that to the proper authorities, whether that's Adult Protective Services, it's the Cabinet for Health and Family Services. If it is found that you knew that there was something that was going on and you do not report it, there's a possibility that you yourself could actually be held responsible, not totally responsible, but somewhat responsible for the exploitation continuing. So just to keep in the back of your mind that if you are in for a penny, in for a pound, if you are volunteering to be someone's caregiver, that this is a responsibility that is placed upon you acting in that capacity. So ethical duty, when obtaining medical care for elderly patients, is imperative to make sure that there'll be funds for those needed services. It might be necessary to look into assisted living or downsizing the home. About 75–80% of our clients are in the situation where, one, they are either about to move out of their home and are starting to look for assisted living, or they are about to start looking for skilled nursing, and they want to understand what are the pros, what are the cons of selling your house or transferring your house to your children. What kind of documents do you need to have in place? So in order to be able to pay someone's bills as either their power of attorney or acting in their capacity, what are you on the hook for? Because in a lot of those situations, if you're someone's power of attorney, if you sign them into a hospital, if you sign them into a skilled nursing facility, they kind of have you in those situations. They hand you a packet of information. It's 35, 40 pages long. Somewhere built into there's arbitration, mediation. There's all these things to kind of scare you, to say we have all the power, you have nothing. But at that point, what are your options really? This person needs medical care. They need somewhere to stay. So everyone signs. What you need to be aware of is that if you're acting as someone's power of attorney and you sign someone into a skilled nursing, assisted living, or one of those, so it's the one thing that you need to be aware of is that you are not going to be held personally responsible for those debts. The Kentucky Supreme Court and the U.S. Supreme Court heard a case. It's called Kindred Care. I forget, it was about 3 or 4 years ago, but they specifically stated that a third party is not responsible for the bills of a person that's seeking care in a skilled nursing facility or an assisted living facility. So if you're signing someone in, they're responsible, but you are not going to be held personally responsible for their medical bills once they are in the facility. So what kind of ethical issues as a caregiver do you need to be aware of? A lot of times when acting as caregiver, the gamut of the administrative bodies that are out there, Medicare, Medicaid, Social Security, a lot of times we do a lot of work with veterans. There are VA pension benefits that are available for in-home care and assisted living care for veterans and their widows that a lot of times people don't know are available. It has nothing to do with the person being injured while they were in the military. It just has to do with the fact that they were in the military and now they're needing to receive medical care. They're private insurance companies. There's Medicare supplements. A lot of times there are long-term care insurance policies that are in place. Long-term care insurance companies, for the most part, not all of them, but for the most part, are notoriously stingy with having their payments actually kick in, even though someone has paid over the course of 10, 15, 20 years. In order to qualify, they're an insurance company. Their qualifiers are 20 pages long, and they can get very confusing. And their initial response almost always is to deny the initial application. So knowing in advance long-term care insurance, what the qualifiers are based off of the policy, checking to see if veterans pension benefits or widow pension benefits are a possibility. Knowing when Medicare and when Medicaid actually kick in to pay. A lot of times when I talk with clients, they think if I go into a skilled nursing facility, that Medicare is going to pay for your care. No, it's not. If you go into a skilled nursing facility and you have to go directly from a hospital to a skilled nursing facility for what's called rehabilitation, and Medicare will pay the first 30 days. And then sometimes they'll pay a share or a percentage of the stay up to a certain amount of time. But usually after 30 days, they say that the person is stable. And now you either need to come up with another way to pay or you need to apply for Medicaid. And in most cases, over half the people that are in skilled nursing facilities in the state of Kentucky, their bills in the skilled nursing facility are paid by Medicaid. So being familiar in advance with what is available, things, checking boxes off the list of what kind of things you need to be concerned with and what kind of things you need to be prepared for based on where your person that you're caring for might end up or is going to end up or might currently be. Acting as a witness. I generally suggest that people, especially in a caregiver role, you also need to know that if there is some chance that you might be a interested party, if the person you are caring for is going to leave you something, you generally should not act as a witness. The powers of attorney that I explained earlier, they've completely revamped the power of attorney law in the state of Kentucky now twice in the last 2.5 years. 3 years ago, you just had to have a notary. Then 2.5 years ago, they changed it where the power of attorney needed 2 witnesses and a notary. Now this past summer in June, they completely revamped it again to say, no, you don't need 2 witnesses anymore. You just now need a notary. But there are certain criteria that your power of attorney now has to follow. It's more of a check box. They adopted the Uniform Power of Attorney Act, and it is quite extensive. I suggest now, where 3 years ago it used to be when you just needed a notary, that a lot of times the power of attorney that you found online might have done the job in 80-90% of the cases. For right now, I would suggest for a power of attorney, you go and talk with an attorney since all of the changes that have taken place. And as a caregiver, I generally don't suggest that you act as a witness. If you're a notary, they've changed the law now too, that for the notary, you can't be an interested party if you're going to be a notary. I redid my father's will actually yesterday and realized halfway through that they had changed the law and I could not be the notary. So in the room, we had to get 2 witnesses to come in and a notary that were disinterested in order to get his will signed. In the event that you're taking care of someone and you need to make the decisions that we've talked about, you need to make healthcare decisions. You need to be able to handle someone's finances, to pay their bills, to buy and sell property. In the event that you don't have those in place, or that your powers of attorney don't cover the things that you need them to, then generally a lot of situations, your only alternative is to apply for guardianship over your person. In order to do that, it's a very frustrating and overburdensome steps that you have to take in order to go through guardianship. Now, with some people, I've heard that it goes through pretty quickly. I've never had a situation where it's taken less than 4 or 5 months. Usually, almost always, something goes wrong. In Fayette County, I know that they're running about 3 months behind, especially now. Everything's backed up. It's a little bit better because up until 2 years ago, you had to have a jury trial when you wanted to get guardianship over an adult. If you end up needing to get guardianship over someone, you have to apply in Fayette County in mental health court. Then reports have to be completed by a social worker, a psychologist, and a primary care physician saying that the person needs a guardian. A court-ordered attorney will represent them. The county attorney will bring the case against the person, and they'll have a bench trial to consider whether the person needs guardianship or not. It's a long, drawn-out process and can become quite expensive. If you had powers of attorney in place, you would be able to circumvent that situation. So this just goes into a little bit about guardianship. I have a few examples of some horror stories that I've had in dealing with some of these situations where someone either doesn't have a will in place or doesn't have their powers of attorney in place, and what can happen in a family situation. So with this case, we'll call him Mr. Smith. He's an 82-year-old man currently living on his own with the assistance of a woman who manages his rental apartments for him. Mr. Smith is estranged from his 3 adult children and recently became divorced from his longtime wife. The purpose for the divorce was to avoid large tax penalties. Mr. Smith has no power of attorney or healthcare surrogate in place, but has executed 3 different wills in the past 3 years, adding the woman who manages his property to the will and removing one of his daughters. Mr. Smith then becomes ill and goes to an emergency room where he stays overnight for a week and at the local hospital. From the hospital, he is sent to a nursing home for rehabilitation. While in the nursing home, he is discharged to his daughter, who does not let the rest of the family know. While at the daughter's house, the daughter who has been removed from the will applies for emergency guardianship. 3 weeks later, the family becomes informed that he was discharged to his daughter. Mr. Smith is unable to talk because of the very strong and large amounts of medication that he is now taking under the supervision of his daughter. Mr. Smith has also had a change of heart and executes a new will, adding his daughter back. The remaining siblings now apply for guardianship for their father. Mr. Smith, the daughter taking care of the father also applies for guardianship. So now what? So this was an actual case that I was appointed as the guardian by the state because you had family members who had jumped in and everyone applied to be the person's guardian. And because he didn't have a power of attorney in place, all that the state could do, or all that the judge could do, was allow them to fight over this gentleman. And they fought for about a year and a half. The gentleman finally passed away, and that was 5 years ago. It is 12:20 right now. In about 30 minutes, I have to leave to go to court because we are still handling his estate. This is going on year 5 now. The only people that are making any money or doing anything with this case, there are 5 attorneys that are involved, and nothing's getting done. So if this gentleman would have had a power of attorney in place at the time that he passed away, the guardianship court says if you have a power of attorney in place, there's no need for guardianship. That person is able to act on your behalf. The family wouldn't have jumped in. The family, every time one of the children was able to get a hold of the gentleman, they would go away for a little bit, and hey, he would sign a new will, and then they'd come back. So 4 years later, they're still fighting over this estate when a power of attorney that was that would have been signed properly would have been enough. Here's another case. Miss Wilson is 78 years old and suffers from Alzheimer's. Miss Wilson has 4 daughters. 2 of the daughters believe that Miss Wilson should be receiving around-the-clock care from qualified medical staff. 2 of the daughters believe there is no need to spend all of mom's money when the daughters could take turns watching mom. Miss Wilson has 3 different powers of attorney and 3 different wills drafted by 2 separate attorneys in the last 4 years. Every time one side of the daughters watches mom for an extended period of time, a new power of attorney granting those daughters the power is executed. Finally, the 2 daughters who do not want in-home care complain that the other 2 daughters are giving too much medication to their mother and file for guardianship. While going through the process of court proceedings, an attorney is appointed by the cabinet to act as conservator. Conservator is a guardian who's only able to make financial decisions for a person. So if you have a situation in guardianship where someone might be able to handle all of their personal decisions, but might not just be able to handle finances, in those situations, sometimes a conservator will be appointed, or someone can apply to be that person's conservator, and all they are allowed to do is handle that person's finances. They can't tell which doctor to go to. They can't say where the person can live. They're purely there to pay bills and handle their finances. The conservator notices while going through Miss Wilson's old bank records, lots of inconsistencies, ATM withdrawals. He relays it to the presiding judge. It's clear that the 2 daughters who don't want around-the-clock care for their mother are slowly draining her bank account. A trial is held. Who should be the guardian for Miss Wilson? Social workers who helped Miss Wilson are called on as witnesses, and some are verbally attacked by the opposing counsel. This woman passed away 3 years ago, and her 4 daughters are still fighting in court over her estate. And she had way less than the other case that I'm going to go to court for. They have fought for years and years and years over her stuff, and her stuff is not worth fighting over. It's a situation where if her documentation, her power of attorney, or her will would have been drafted in a way that would have made it a lot more clear who she wanted in charge, they could have avoided a lot of this situation. So I think this might be the last one, and then after that I can take questions. So Mr. Baxter lives in the home with Miss Baxter. It's a second marriage for both of them, and they are both children from a previous marriage. Mr. Baxter is 78 years old and suffers from Parkinson's and early onset dementia. Miss Baxter is 77 and in decent health, but trying to care for him by herself is taking its burden on Miss Baxter. Mr. and Miss Baxter have no powers of attorney or healthcare surrogate paperwork. In order to get some help, Mr. Baxter and Miss Baxter calls Mr. Baxter's daughter, who lives nearby, for some help. Mr. Baxter's daughter has not been Mr. Baxter in a while, and when she does, is mortified by his descent in health. She calls Adult Protective Services. APS arrives at the Baxter home a few days later with Mr. Baxter's daughter. Mr. Baxter's siblings, and a police officer. I can go ahead and skip to the end and tell you how this story ends. So, how that story ends up is the daughter whisks the husband away under the pretense that she's going to take care of him for a few days. She takes him about 3 hours away and applies for emergency guardianship over the father. It's granted. Now, when you apply for emergency guardianship, you still have to go for full guardianship, but it buys you time. And in that time, she emptied his bank account. She transferred all of his things to herself. It took about 2 years for us to get it all unraveled and back to where it needed to go. Eventually we were able to, but at a large expense and cost in terms of time, energy, and just emotions, really. The family was never the same. And if proper paperwork would have been in place in regards to a power of attorney, it would have prevented the daughter from being able to whisk the husband away. So wrapping up, what we see as the attorney's role in these situations is a family counselor, a financial navigator, and an advocate. We really want to be just a resource center for our clients. We help clients with dignity. We provide clients with options, place clients in charge of their future, and identify who will care for clients and help them manage their assets. So now's a good time for questions. I'm not sure functionally how